Thank you very much, Claire, and welcome to everybody attending today. This should be around 45 minutes as a session. I will stick around at the end. I know we've already had a few questions emailed over, and obviously I'll answer those, plus anything else that crops up as we're working our way through this today. By way of background, Annecto Legal is a broker for after the event insurance and litigation funding. We've been going for just over 10 years. Prior to that, I worked in the legal costs sector, looking at retainers, funding and insurance from a slightly different perspective. And yeah, been around this area for quite a while. So if you do have any questions, hopefully I'll be able to answer them. If not, certainly do my best to find an answer for you and get back to you. A big part of understanding funding and insurance is really just about allowing your clients to be able to make informed choices about how they manage their risk around dispute resolution. And that's really what we'll be looking at today from an ATE perspective. So what are the financial risks that your clients face? What options do they have available to them through the use of after the event legal expenses insurance? How can that be utilised? When is it best utilised? What are some of the downside risks of taking AT on board? And also, how do you go about actually accessing those kind of products? What information is required? Who in the market provides it, that type of information. From a client's perspective, first of all, we'll just look at the kinds of risks they face, because I think it's useful to take a kind of step back away from the insurance product itself and go, okay, you're a client having to litigate. What are the kinds of decisions you are having to make financially, and how's this going to bear on your business or on you individually? What types of risks are you facing? So obviously one of them is just general uncertainty around their own costs, what they might be exposed to, however long a dispute runs on for, as well as that time frame of how those costs might be spread out. And that can have a particular impact from an accounting point of view, which we'll look at in a second. They've also got that risk of losing the case and having to write off any costs at the end, as well as potentially having to pay their opponents' costs too. We'll look at security for costs, which is becoming more and more of an issue now around disputes. Being used very much as a tactical tool by defendants in a lot of disputes now. And there are things that can be done to mitigate that kind of risk using different types of insurance products. I draw quite a clear distinction between things that are insurable and things that are fundable. So basically anything that's risk, generally you'll look towards insurance because that's a cheaper option. Anything that actually requires cash on an ongoing basis is really a funding solution. And we're not particularly looking at that today. It's going to be really just around the risk in the insurance product. So from a client's perspective, let's just have a look at what are their considerations basically when they're thinking about pursuing a dispute. So I've used some kind of just very broad numbers here. I haven't put any number next to it. So this could be thousands, it could be hundreds of thousands, it could be millions, it could be whatever you want it to be, quite frankly. It's more a conceptual thing that we're looking at here rather than any specifics around numbers. So your client is thinking about pursuing a claim. Their claim is 30 in value, and that's presented in the green bar here. You've told them that their own costs are likely to be somewhere around 2, whatever 2 means, and therefore their overall risk is their costs plus the risks of adverse costs, which you've estimated at another 2. So you've got the grey bar, which is their actual financial outgoings of 2 to finance their litigation. And the red bar is the overall risk, which is their costs plus the potential liability, their opponent's costs, totaling 4. Now, this is all stuff that's going to sit on the balance sheet of a business. The claim itself is a potential contingent asset, and that has a place on a business's balance sheet. The costs, the hard costs, if you like, the 2, they're very real, and the only place they can really come out of is the bottom line of a business. It's going to impact on profitability. That's the only place it can come from. It's not like they're selling more stuff in order to pay your legal bills. The risk side, so the risk of having to write off that money and having to pay the other side's legal costs, that's a contingent liability. Again, has a place on the balance sheet, has to be held in reserve, will impact on the accounts for the period of time that it is held in reserve for that business. Because those costs sit on the balance sheet, they actually have a drag on the accounts. And most businesses you work with will be accounting using something called EBITDA, earnings before interest, tax, depreciation, amortization. What that means is anything that sits on the balance sheet as a negative will generally go through a kind of multiplier effect in terms of what's the real impact on the business of the value of the company, its ability to raise finances, to sell, to acquire other businesses, its share value, its profitability. All these things go through this multiplier effect. So you see the 2 here. If we use just a pretty standard multiplier of 5, which is not big at all in these kind of scenarios, the real drag on the business is a -10 drag just on their own legal spend. And obviously the 4 multiplied by 5 is -20. So these things have really big impacts on a business's accounts. And it's not stuff that generally they've budgeted for because it's litigation. The key takeaway from this as well is that even if the litigation is successful and they make a recovery of that 30 that they were suing the other side for, well, that comes into the balance sheet as a one-off hit. It's not something that will replace the damage done over the last couple of years of those hard costs going out. So if anyone comes to value that business, they'll look at that one-off exceptional item and they won't go, oh, you know, this business is very profitable because it's just won a piece of litigation. They'll essentially ignore that as just a one-off, but they will look at the profitability over the last couple of years. And because of that's been diminished by the legal costs that have been spent during that time, that still sits there. So my point is, even in successful litigation, you're doing short and medium-term damage to a business's accounts that you can't fix even by winning. And I think a lot of people, from a legal perspective, don't really see that and see the kind of choices that companies have to make when they're having to reserve funds for legal spend and also for the potential risk of losing. So it's worth just being aware of what businesses are having to think about when they're considering pursuing a dispute. And obviously anything that, any obstacles to them bringing a dispute to you are things that are going to prevent them from pursuing that, prevent them from instructing you, prevent you from getting that work and that fee earning work, which is obviously very important for your practice. It also prevents them from pursuing the claim and potentially getting that money back that they should be entitled to. So what we're talking about here with after the event insurance in particular is about shifting risk off the balance sheet, moving it onto an insurer's balance sheet instead. And what it does, it cleans up the accounts for the business. So those risks that they had previously now sit elsewhere. They've still got that contingent asset, which now might be worth slightly less to them because they're going to have to pay for an insurance product at the end of all of this. But that's actually something that doesn't have a massive impact on their accounts. Whereas those real drags on the business of the spending and the reserves do have a huge impact. So it's important to see, you know, what they're thinking about, I suppose, before they embark on this. So that's just a little bit of background for how clients are perceiving the risks around litigation. What are the options then from the client's perspective? Well, you know, all cases are funded one way or another. They're either funded by the client, they're funded by you on some kind of risk-sharing agreement, such as a conditional fee agreement or a damages-based agreement, God forbid. Or a third party stepping in and actually funding the legal bills. So a third party litigation funder, for example. They're all about the financing side. And then on the downside risk, so the adverse cost risk, what you've got there are generally insurance options. So either a before the event insurance policy that they can make use of, and it's always worth asking clients if they do have any products that might be of use, or an after the event policy that they take out when the litigation's arisen and protects them from having to pay the other side's legal costs. Obviously, all these things can be used in conjunction with one another as well. And really the three things you're normally thinking about are, what's the client actually investing here? You know, what's your retainer? What's the insurance? And sorry, someone's just sent a message and it's just distracted me slightly, but I'll move on to that at the end. So what is after the event legal expenses insurance? Well, it's slightly different than the vast majority of insurance that you'll be familiar with. So, you know, car insurance, home insurance, holiday insurance, whatever it might be, is typically a product where you tell an insurance company what it is you would like to insure. You then pay them for that insurance. And if something goes wrong in the future, you would hope that that policy will pay out for whatever losses you've experienced. That's typical insurance. That's before the event. So, before you've been burgled or had a problem with your holidays, when you take out that type of insurance, not afterwards. After the event, the name is self-explanatory. Something's already gone wrong. You're now having to litigate to resolve that problem, and then you take out the insurance. Now, it works in a very different way, because typically what you're not doing is actually paying for that insurance at the point when you acquire it. What you're usually saying to the insurance company is, we've got these contingent risks around the litigation. So basically, we're worried we might have to pay the other side's legal costs if we lose. We'd like you as the insurer to put that risk on your balance sheet and provide us with an insurance policy. We won't pay you anything now, but if and when we win, then we will pay you for the insurance. So it's perhaps a little bit easier to think of it in the context of a swap rather than how you might consider a typical BTE, before the event insurance product. So the client's swapping their obligation to pay the opponent if they lose. They're swapping that with an obligation to pay the insurance company if and when they win. And the reasons that can be attractive to a client is, number one, they've actually moved that risk off their own balance sheet, so already they're ahead. Number two, the insurance product will cost less than what the adverse costs would be, and we'll talk a little bit about pricing shortly. And thirdly, if a client runs a dispute, loses, has to write up all their own legal costs, and then also has to write a check for the other side's legal costs, having lost the claim, they're probably in a pretty bad financial position at that point. Number one, something had probably already gone wrong for them to having to be litigate. A second thing has gone wrong where they've spent lots of money on it and had to write it off. And now a third thing is going wrong in that they're having to pay the other side's legal costs as well. So it's not a great time for them to be writing a check. Obviously, by taking out the insurance product, they're no longer writing a check in that scenario. The insurance company is paying the other side's legal costs. The scenario now where your client would actually be writing a check is when they win. And hopefully they'll be in a much better financial position, having been successful in the litigation, than if they'd been unsuccessful. So it's a better time to be actually paying something, as well as it being cheaper. And obviously the financial advantages of not having that risk on their balance sheet during the whole dispute as well. There's kind of three different types of premium. Two of them are summarized in the paid premium model. The most common form of ATE premium is a deferred and contingent premium. So as I say, you say to the insurance company, we think the risks on this claim are, say, £200,000 of adverse costs. We would like you to provide us with a policy for £200,000 of adverse costs. You give us that insurance today. We will pay you on a deferred and contingent basis. So deferred to conclusion of the claim and contingent upon being successful in the claim. So the claim's unsuccessful, you'll have paid nothing to the insurer at all, and the insurer will pay your opponent. If and when you're successful, you will then pay the insurance company, or your client would pay the insurance company. The amount that you pay the insurance company is determined by, number one, the amount of insurance you need. So it's not about the value of the claim, it's about the amount of insurance you need, which typically would be the size of any potential adverse costs award you think you might face. So using the example of £200,000 of adverse costs, if you settled the claim early, so relatively soon after issue, the price of that £200,000 of insurance would likely be somewhere in the region of 10, 15, maybe as much as 20%, depends on how you've structured the premium. So typically you can have a low premium for early settlement, but then it might get quite high if you go all the way to trial, or you could have one that's maybe a little bit more expensive if you settle early, but a little bit cheaper if you go all the way to trial. So a flatter line, really. So which option you choose is a little bit trying to guess what might happen in the future. If you think a case might go all the way to trial, you might prefer a premium that's a bit more expensive today if it settles, but it means the cost is kept really low if you go all the way to trial and win. And that's sort of the amount insured. So again, using that example of £200,000, let's say you settle pretty soon after issue, the client's going to pay the insurance company £20,000 at that point, 10% of the 200,000. There is VAT to be paid on insurance. It's called insurance premium tax, IPT. It's presently 12%. So if your client had to pay £20,000 to the premium, they'd also have to pay 12% IPT on that as well. As the claim develops, typically that deferred and contingent premium will rise in 3 or 4 stages as the case progresses. So if you go all the way to trial, the premium could be either side of, say, 50% of the amount insured. So in our example, around £100,000 if you win at trial for £200,000 of cover. And that will normally rise, say, so your first stage premium would be if you settle not long after issue. It might jump up, say, 10% if you settle not long after exchanging witness statements, for example. It might jump up another 10% if you get as far as exchanging expert evidence. Might be a final stage that kicks in, say, a few months before trial, and then the actual trial premium. So you're not paying these stages. This is just what would the insurance cost your client if you settled at one of these points in time during the dispute. So typically you might find a claim settles somewhere around the disclosure point, and the premium at that stage might be around 30%. So that's a deferred and contingent model. So nothing paid unless and until you win or settle the claim. The paid premium model is slightly different. So there you might either pay outright for a policy up front, so more akin to kind of traditional insurance. And for that, you might pay 25 to 35%, say, of the amount of cover you need. And it might be in the client's interest to go, look, I just want to pay for this outright at the outset and know that I don't have to pay anything further if the claim wins, goes all the way to trial or whatever. Obviously, if it goes to trial, and they win, they've essentially got a cheaper premium at that point than the, say, 50 or 60% they might have spent going all the way to trial. But if it does settle early, they might, in theory, have kind of overpaid for that premium that they could have got a lot cheaper for an early settlement. So those kind of fully upfront premiums are pretty rare. There are certain circumstances where it might be a useful thing to do, but they're not very common forms of premium. One that's slightly more common is a stage paid premium. So again, you might have 3 or 4 stages for the litigation, and as those stages arise, you would actually pay the premium as each of those stages kicks in. So again, it reduces the overall price because you're paying as you go. But again, not massively attractive from the client's point of view if the alternative would be pay nothing and just get a deferred and contingent premium all the way to the end of the trial. The final form of premium is partially paid with the rest deferred and contingent. And that's becoming the most common form of insurance. And the reason that's becoming the most common is not because clients are pushing it, but insurers are. So it's getting harder to get fully deferred and fully contingent premiums. It's still possible. Some insurers will do it some of the time, for some cases, basically. But on a lot of cases now, you're finding that insurers want, say, 10% or 15% as a deposit premium paid when the claim's issued. They keep that. Even if the case loses, they would have been paid that 10%, say. But if the case wins, then they would be paid the rest of the premium they're due at that point under that deferred and contingent model. So again, based on how much insurance you have and at what stage of the dispute you actually settle. ATE insurance is typically the most cost-effective way of dealing with a security for costs application made against your client. So your opponent says, look, we don't think your client's got the funds here to pay our costs if we successfully defend this claim. We want your client to put, let's use the same example I was using earlier, £200,000 to cover our costs. We want your client to put £200,000 into court so that it's available to us should we successfully defend this claim. Now, your opponent might have legitimate concerns about the financial viability of your client, and they might genuinely believe they're likely to win the litigation and therefore want some security over costs. That might be the case. What's more likely to be the case is that they see this as a useful tactical tool to try and stifle a claim, try and make life harder for the claimant to pursue the claim against them. So, the standard defense in litigation is, defend the claim if you can. If you can't, find whatever tools are available to you to make life very, very hard for the claimant. So that could be by running up costs, by bringing security for cost applications, any number of things. But we're seeing a big rise over the last few years in the amount of security for cost applications being brought. Typically, a cost-effective way of dealing with this is, rather than your client lodging £200,000 of cash at court, is to provide an ATE policy. So that gives your opponent some certainty that if they successfully defend the claim, they would have the benefit of that policy to pay their costs. Now, again, for either genuine reasons of concern or for tactical reasons, the defendants may raise some issues around the policy and say, well, actually, we don't think this ATE policy is good enough for security because we're accusing your client of lying. If we successfully defend this claim, we'll have shown the claimant to have been a liar. And in the event that the claimant's lying, they could well have lied to their insurance company in their ATE application. And as with any insurance, if you lie in your application, the insurer can use that as a reason to void the policy. So the defendants could argue that, look, if we successfully defend the claim, by definition, actually the policy is unlikely to respond and pay out our costs. So it doesn't really provide us with any security at all. And that leaves you with a couple of options, really. So go back to your insurance company and say to them, look, these are the issues being raised by the defendants. Can we either take out these clauses that allow you to void the policy? So that's providing an anti-avoidance endorsement. Or can you provide us with a separate deed of indemnity, an irrevocable guarantee of payment in the event that a costs award is made against your client? Dealing with an anti-avoidance endorsement, first of all, these are generally perceived as being a slightly less robust solution than a deed of indemnity, but satisfactory in the vast majority of circumstances and more attractive for your clients because often they're cheaper than a deed of indemnity. And if you've already got a deferred and contingent policy or a largely deferred and contingent premium, it may be that you can get an endorsement on that policy by simply adding a small cost onto that deferred and contingent element of the premium. So there wouldn't be any upfront physical cost to the client of securing this endorsement. And obviously that's beneficial. The alternative is that you take out a deed of indemnity and the market norm for those is 10% of the level of the deed that you need. So using our ongoing example of the other side, say they want £200,000 of security, you would likely have to spend £20,000 to secure that deed of indemnity. Deeds are not insurance products. They're a deed. It's an entirely different thing altogether. And so they do not attract insurance premium tax or VAT. So it would just be the 10% you'd be paying, nothing else on top of that. There is some variation between different insurers about what they charge for deeds, but the 10% is pretty likely to be the cost of it. You can't, or I've never seen a circumstance where the cost of a deed of indemnity has been deferred until the conclusion. That's generally a hard physical cost to the client that they have to actually write a check for, or a third-party funder would have to write a check for if they're supporting the claim. One of the things you can do is say to the court and to your opponent, look, we're happy to provide a deed for £200,000, But we don't think we need to provide all £200,000 at the outset of the litigation, because you're telling us your costs will be 200,000 if you go all the way to trial. Well, we're nowhere near trial yet. So right now, we'll provide you with £50,000 as a deed. We've already got our AT insurance for 200,000, but we'll buy a deed for £50,000, and then at a stage in the litigation where it's likely that that £50,000 is no longer adequate, we'll purchase, say, a further £50,000 of deed to sit alongside the ATE policy. And only in the event that this thing goes all the way to trial will we actually procure deeds to the total value of 200,000. What that means is, instead of having to write a check at the outset for, say, £20,000, the client could make it more manageable chunks. And clearly, you know, if security costs like £1 million or £2 million or something like that, these upfront elements can get quite large quite quickly. So thinking about how to stage it is often a very sensible way of doing it, rather than just putting loads of money into this right away at the outset. Because these things are non-recoverable. ATE premiums, deed of indemnity costs, funding costs, these aren't things you're going to recover, or your client's going to recover from the other side, even if in the event that they're successful. They're essentially going to be deductions from their damages in essence. Just to mention briefly, because the focus really on this talk is around ATE insurance and not around other forms of funding. But I mention it because it's becoming a more and more common thing now for ATE insurers to provide a policy that doesn't just cover your opponent's costs, but could also cover some or all of your costs as well. The reasons why that might be attractive are, you might say to your insurer, look, we want £200,000 of cover for the other side if this claim loses, and you pay that £200,000 to our opponent. But we'd also like to insure, say, £100,000 for our disbursement and counsel fees that we're going to incur on this case. And the reason we'd like to do that is because the client wants some comfort that if this case does lose, they're going to get £100,000 of their investment back. So they're not going to be writing off all £200,000 they've put into this litigation. They're only going to be writing off half of that. Or it might be something where, on an insolvency matter, for example, having the benefit of that insurance around your own costs might allow a liquidator to, say, use monies from an estate to pursue litigation, where, because they've got the protection of the insurance, they know that money's coming back to them if the claim fails, which makes them a lot more confident about putting that money in from the estate, rather than having the risk of having to write that off. It may be something, again, where a liquidator could use that benefit of that insurance around the own costs to approach creditors and say, look, we'd like you to support this litigation, help us. We just need you to help actually cash flow the case as it progresses. And finally, there are two other things where that insurance might be useful. So number one, if you're acting on a conditional fee agreement or a damages-based agreement, basically something where you've got fees at risk, having the benefit of an insurance policy that, say, protects perhaps 50% of your work in progress, having the benefit of that safety net means that if everything does go wrong and the case loses, you would get 50% of your WIP paid to you at the end of the case. You wouldn't just be writing off all of the work in progress that you've built up during the lifetime of that claim, which could be significant if it's something that goes all the way to trial and loses, of course. And finally, having the benefit of that insurance can be helpful if you want to secure more cost-effective funding from a third party. So typically, people's expectations around third-party funding is that the funder will take 30% of the claim value, or 3 times their investment into the case, as a reward for successful claims. That's quite expensive. Your client may benefit from taking out insurance, which, as we've seen, is a fraction of the cost of litigation funding, and then using the benefit of that insurance to be able to secure much cheaper funding from a third party, which again could be a third party litigation funder, it could be a bank, it could be some other source of capital, it could be, you know, friends and family. But having the benefit of that insurance means that it's a much lower risk for whoever's financing the claim, and allows you to therefore get much better terms from the investor. Now, you would be buying more insurance by insuring your own costs. So there's an increased cost there, but you save so much money on reducing the costs of third-party funding that it more than pays for itself. So you can typically get funding at maybe in the region of like 30% per annum, something like that. So if you needed £100,000 on a claim, it'd have to run for 3 years in order to make a 1 times return back to the funder. That's obviously massively less than the 3 times return that people expect for third-party funding. So I just mentioned that because obviously the primary reason for taking out ATE insurance is to protect from the risk of losing and paying your opponent's costs. But as I say, it's becoming more and more common now for those same policies to be expanded out and to be used to cover disbursements and even own solicitors' fees in cases too, for any number of reasons as we've discussed there. The pricing tends to be pretty similar to what you would pay for AT insurance, and works in a very similar way. So, you know, perhaps a down payment with the rest deferred and contingent to conclusion of the claim. The kind of decisions that underwriters have to take when they're looking at any piece of litigation are: how big is the investment? Over what likely time frame is this dispute going to run? So, you know, do you think you're going to get a court date for, say, 18 months' time, or is it going to be 3 years down the line before this actually gets into final hearing? The longer something goes on from an insurance point of view, actually, the slightly better from the insurer's perspective, weirdly. It's the exact opposite of litigation funding. So litigation funders generally would like things to resolve quickly because they want to make a return fast on their money and then reinvest their money in other cases. And the longer their money is out for, the more expensive it becomes to them to actually get that capital and keep it out the door invested in your case. You know, there's annualized returns on that. Whereas from an insurance point of view, you'd actually rather trial was quite a way off in the distance, because what you just don't want is to lose. And the way that you lose in insurance is by going to trial and losing at trial. So that's a way off. Actually, that's quite good from an insurance perspective, because it means you definitely can't lose until then. You may have to make adverse cost payments around certain interlocutories and things like that. The policy covers those, but by and large, the real losses are going to come, you know, at the end of the claim. So understanding what kind of time frame you're working to is helpful. There may be some tension there between what kind of time frame works best for a funder versus what might work best for an insurer, but they're surmountable. Then you're looking at things like legal merits, the actual law. You know, is it on your side for this case? Have we got the documents to support our claim, or are we entirely reliant upon witness evidence? That tends to be quite scary from an underwriting perspective, knowing that whether you win or lose is entirely reliant upon how well your witness performs on any given day, you know, 2 years hence. Cases that are backed by documents are much more favourable from an underwriting perspective, whether as a funder or an insurer. Thinking about not just what your actual claim for damages are, but number one, what's a realistic settlement figure around this? Both in terms of what you think the claim is really worth, but also what your client realistically would walk away with. You know, is your client determined to get absolutely every penny possible out of this claim, or are they quite commercially minded and would see the advantage in doing a deal, getting something and walking away and getting on with their life? So thinking about that, and obviously, what's the position of the defendant? Have they got the assets to be able to satisfy any judgment against them or do a deal? If they don't, then it doesn't matter how good your claim is and in terms of merits and everything else. If the other side doesn't have any money, well, that's not going to be good from an underwriting perspective. You will not get people backing those sorts of cases for obvious reasons. And I mean, the question would be why your client even wants to pursue it anyway if they're spending money on a dispute where they don't think the other side's actually good for it. Finally, you can then start to play around with the numbers in terms of what's the likely return on investment. So, how much is going to be spent on this over what kind of time period? What's the potential payoff? Who's actually financing the claim? What type of return do they need on that investment? And what can we insure? And what's the cost of that insurance? So that's really the thinking. And to be honest, I mean, these are all things that any client should be thinking about before they pursue litigation, regardless of whether there's an insurer involved or not. The when, so let's keep an eye on time. One thing I think is worth bearing in mind is that lots of clients don't even get as far as picking up the phone to you. They know just enough about litigation to know it's expensive and it's risky. And they may decide, without going any further, that actually they're not going to do anything about this problem at all. So just making prospective clients aware that, yes, litigation is risky and expensive, but there are options available that could assist them in managing that risk and expense. That's a useful message to get out into the world, because it then allows people to actually pick up the phone and contact you and have the conversation with you about it, rather than just dismissing it out of hand themselves. So it's well worth you not just letting your own clients and prospective clients know about this, but also your professional referrer network. So, the accountants and IFAs and people like that that potentially are sources of work for you. And also internally, within your firm, is your corporate department aware of these tools being available, or are they actually preventing clients from pursuing litigation because they're spreading the message far and wide that litigation is risky and expensive and you probably best avoid it at all costs? So just having your firm be aware that these kinds of things are out there can be really useful in just removing one of the barriers to people even talking to you about pursuing disputes through the courts. Obviously, around first client meeting, when clients are asking you, what's this going to cost me? It can be very difficult in that scenario for a solicitor to answer that question without prevaricating about, lengths of string and things of that nature. If a client asks, how much is this going to cost me? Well, actually, it doesn't really matter how much the litigation might end up costing. You could cap their exposure at the level that they're willing to invest in the claim. Because what you could say is, look, we can provide you with a solution where we can cap your spend at, say, £50,000 or £100,000 or whatever, is appropriate for that client. Then use insurance or insurance plus funding in order to be able to fill the gap that the client can't fill. So the client could actually embark on litigation knowing that there is actually a limit to what this is going to end up costing them. And they're not just entering into a process which feels a bit like a bottomless pit where you don't really know how much all of this could go, how long it could go on for, or how much it might end up costing. I think another time to consider insurance and just general kind of funding options is at times where clients say during a case, look, we think we need to just hold off on doing the next phase of the dispute because we need to release some money from other assets, or we're doing something with our business that means we can't really afford to spend on the litigation at this point in time. We'll be in a better position a few months down the line. That can be a good time to be proactive and go, okay, is it worth having a conversation about other risk management tools, whether it's insurance or funding, to actually help the client be able to bridge these problems rather than having the litigation go quiet for a period of time? Because we all know, if you're a defendant in a case and the claimant is very stop-start around how they're progressing the dispute, you're very unlikely to want to settle that on very good terms, because you might have the feeling, well, we don't think this opponent's really got the wherewithal to see this all the way through to trial. So let's just hold fire on settling this, so see whether the guys can really see it through to the end. Whereas if a client's well-resourced or well-supported by funding, insurance, able to progress the litigation quickly, they can actually drive the claim to a much better settlement and a much quicker settlement, which actually might negate any of the costs of the funding and insurance anyway, by being able to do that deal faster rather than having it be way off into the future and end up costing a lot more to get there. And I've mentioned already around the security for cost issues. Just one other thing, kind of post-judgment, insurance can be useful there. So you see it on bigger cases where you might have arbitration default insurance. So basically you've got a judgment against a sovereign and the client's worried about how much it might cost and how long it might take to enforce. They might want to cash in at that point using funding or insurance in order to extract value from that judgment without having to worry about trying to enforce it. It can certainly be used to protect the client from things like cross undertakings for damages around freezing orders, or indeed can be quite supportive if you've got to do further investigations around enforcement, asset tracing, things like that post-judgment. So just some other things worth thinking about, I suppose. Conscious of time here because we're about to hit 1:45, and I know we've already got a few questions that have been posed as well. I'd say as a first step, when you're thinking about would this claim be suitable for underwriting from an insurance perspective, basically, does the claim make commercial sense is a good starting point. You know, how much is it going to cost versus what you're likely to get back at the end of it? Is everyone likely to make money out of this, frankly? Because no funder or insurer is going to want to get involved in something unless there's a good chance of that happening. Are the risks that you see in the claim, and there's always risks in every case, are the risks things that you think you could get an insurer comfortable about? So are they just fundamental problems with the claim, say around limitation or something like that? Or are there issues with the case that you think can be dealt with through disclosure perhaps, or better forensic work being done on the claim, whatever it might be? But have a think about where are the problems, what can be done to address those problems to make underwriters happier. And that's a big part of the process of kind of securing insurance, is being able to work through these issues with underwriters to get them comfortable with it so that they're willing to sign off the risk. So just to summarize, all litigation is risky and expensive, but it's just about where do those risks sit? Do they sit with the client? Do they sit with you because of your retainer? Or do they sit with a third party, be it funder or insurer, on their balance sheet? And then it's all about, okay, thinking about the claim, how do you present that claim best to get the best possible deal? You know, going out to in the right way to the right markets and knowing the kind of structure of deal you want to be able to get the best possible product that's going to help you and help your client. So that's it for the kind of the main part of it. I know there has been some questions coming through.
Hello, Mark, are you still online? Hi, Mark, are you still online? Think you're on mute, sorry.
There we go. Sorry, Claire. I'm sure
That's
that caused you a mild heart attack there. My computer just closed. It's reopened itself, but I just thought I'd jump on my phone while I'm trying to rectify that problem. So sorry about that. It just decided it had enough, probably understandably, and just quit on me.
No problem. Of the questions that I sent you earlier, did you want to cover any of those now while we wait for others to come in from the audience?
Sure. Let me just let me open up your email. I'll do that on my computer now because I'm on, as I say, I'm on my phone now. Can you hear me okay on here, by the way?
Yes, absolutely fine.
Yeah. All right, super. Right. So I know I have answered some of these as we've been going along. So the first question I had was, how can ATE benefit lawyers as well as clients? Well, I think we've talked about some of the ways that it can benefit, but I'd say the main one is, look, we're all called fee earners. So there's a bit of a clue in the name as to what is likely to dictate how well you do in your career. It's about how good a fee earner are you for your practice. Now, you can't fee earn if clients aren't litigating. One of the reasons clients don't litigate is because it's expensive and it's risky. So if you can find ways to remove obstacles to litigation out of clients' way, it's going to allow them to pursue more claims, to pursue those claims for longer, to get a better deal out of it. They're not going to be concerned about just settling for any number as quickly as possible to get out of it if they've got the right kind of backing. So I think, does ATE benefit lawyers as well as clients? Yeah, absolutely. We talked about some of the funding options you can do around it, but I think just in simple terms, if it allows you to do more for your clients, then that's better for you too. How ought to see the impact of quoques on the ATE market? Well, I think anything that gives certainty around what your adverse cost risk is allows you to be very specific about the level of ATE that you need, and therefore, gives you certainty around the cost of that as well. So, it's anything that provides certainty to you and your clients is likely to be quite helpful, I think, certainly from an insurance point of view. You can be very specific about what exactly you need. So I'm just scanning down the questions because some of them we've already covered. Will one policy cover multiple opponents? Yeah, absolutely. So you typically take out a policy to cover a dispute rather than any particular opponent in a dispute. So yes, it would cover multiple opponents. The market for insurance is 15 to 20 credible, decent ATE insurance providers out there. Some of them more interested in smaller cases, some of them more interested in bigger ones, some with more of an appetite for international work, some that particularly specialise in things like insolvency. But there's generally something for everyone. So one of our aims when we go out to market is to make sure we get a good range of options for the client, present it in a way that the client can understand what those different options are, what it means for them. So what that usually means is, what is this going to cost them out of any settlement potentially? And how are those policies structured, and then trying to highlight any areas that are perhaps ripe for negotiation, or any areas of the wording that might be need particular attention. Can ATE cover the costs of instructing expert witnesses? Well, we talked about using ATE to cover your own disbursements. So ATE doesn't give you money unless you lose. So it wouldn't provide funds to pay your expert witness, but you could insure the costs of the expert witness, and as I say, use that insurance to potentially get much cheaper funding to be able to actually pay the expert witness on the case. We've talked about when premiums are realised. Is ATE used as a bluff in litigation to drive up settlement costs when in fact no ATE has been purchased? Well, I guess you could. The difficulty there is if your bluff gets called. I would say generally you're in a much more advantageous position if you actually take out the insurance, because then you can send over a redacted policy to the other side with a policy number on there, so they know it's genuine, it's real, your client has the benefit of it, they're ready to issue their claim, if you like. If you send over detailed particulars and an ATE policy, I think the other side's going to be fairly confident at that point that you're serious about issuing a claim. The downside of doing that would be, well, there's then going to be a cost to the client because they've then taken out that policy. So if they now settle the claim, they're going to have to pay for it. What I would say is you could normally just agree some kind of very low fixed fee. So you'd want to pay something to the insurer if you're successful, because number one, they've done the work to provide the policy. So they've had to due diligence the claim, they've had to provide you with the policy, and your client has derived a benefit from said policy by using it to actually settle their claim. But that fixed fee could be very low. You might be talking like a few £1,000s or something like that. And obviously it's worth much more than that to the client if it gets them a deal done on their case. So I'd say if you're going to bluff, I mean, I'd rather have the cards in my hand rather than be genuinely bluffing, but I guess that's each to their own. What type of claims are most suitable for AT insurance? Well, people use AT insurance in the personal injury and clinical negligence market. They use it around insolvency claims and commercial disputes. I think any case where it's proportional, as in the costs versus what you're likely to recover at the end, where you've got the evidence to support your claim, or some of it at least, and where the other side's likely to be in a financial position to satisfy any judgment. I'd say they're probably the key things. Beyond that, it's, you know, each claim on its merits, really. And what's the role of AT insurance in circumstances where security of costs might be ordered? Yeah, we've kind of dealt with that one, I think, really. So, and I think that's it from the questions that I was sent in advance. Unless anyone's got any more?
If anyone has any questions, please do put them in the Q&A box now whilst we have Mark. We'll just give it a couple of minutes.
What I would say is if anyone has questions around a particular case and it's not really appropriate to be, you know, flagging those up in an open dialogue like this, feel free to drop me a line. I'm sure Claire's circulated our slides and contact details and what have you on there. You're more than welcome to get in touch. Or one of the things we do a lot of is just talking to people about claims, what the art of the possible is around insurance, around funding, so that clients can actually then make a choice about what to do next. You know, do they want to go down an insurance route? Would a funding route be appropriate? What type of retainer might work best on a particular dispute? And we're always happy to chat those things through, even on a kind of no names basis, if that makes more sense at the early stage of dispute, just to give the client a bit of a feel for what you might be able to do for them. And if it helps you onboard the client, obviously that's hugely useful for you as well. But yeah, always happy to chat stuff through, either myself or my colleague David Law, who many of you will be familiar with. He's based over in Bristol.
Wonderful. We haven't had any more questions in, Mark. So
Super.
I'll say thank you very much for such an interesting talk this afternoon. I don't know about the audience, but I've certainly learned a lot this afternoon. And thank you so much. And we look forward to welcoming you back in the future for other talks.
Thank you very much, Claire. All the best. Thanks, everyone.